Ladies and gentlemen, we will now have our first session of the day. This is the Distinguished Speaker Lecture to be delivered by another one of our honored guests, the Attorney General of Singapore, Mr. V.K. Rajah. The session has been very kindly sponsored by the law firm Messrs. Moeddin and Max, and it will be chaired by another household name in our midst today, Dr. Cyrus Das. I describe Dr. Das as being a household name, not least because him and I share the same household, but also because he is widely regarded as being one of the foremost litigators in Malaysia. He has appeared as lead counsel in some of the most important decisions in arbitration in Malaysia in recent times. He is a former president of the Malaysian Bar. He is currently an honorary life president of the Commonwealth Lawyers Association. He is also a fellow of the Malaysian Institute of Arbitrators. Without further ado, could I invite Dr. Das onto the stage to commence our first session.
Thank you, Greg. Yes, I can confirm that we share the same household. Honorable judges, distinguished guests, ladies and gentlemen, I have been given the singular honor and pleasure of introducing our keynote speaker for this morning in the first session for the day, the Honorable Attorney General of Singapore, Mr. V.K. Rajah, SC. His outstanding legal achievements are set out very briefly in the conference handbook, but his unique qualification is that he has had an all-round experience, which I think very few people would have had the opportunity of experiencing, in that in a career of over 30 years, he has interacted with the law on many fronts. First as a practicing lawyer, as a senior counsel, and then I think for many years as managing partner of his law firm, Rajah and Tan, one of the largest law firms in Singapore. He was then appointed as a judge of the Singapore Court of First Instance, a trial judge. He became a judge of the Court of Appeal, and now he's back on his feet as the Attorney General. With that wide experience, Mr. Rajah proposes to address us this morning on the topic of the future of ADR, not alternative dispute resolution, but adversarial dispute resolution. The brief synopsis that he has given would seem to suggest that the status quo cannot remain and that we have to look ahead and look at alternative way of dealing with dispute resolutions. And his keynote address is titled enigmatically as Whither Adversarial Dispute Resolution. Ladies and gentlemen, with great eagerness, we look forward to hearing our distinguished keynote speaker, Mr. Rajah SC. May I invite him now to the stage.
Director KL RCA, Professor Dato' Sundra Rajah, President of the Malaysian Institute of Arbitrators, Mr. Lam Polan, distinguished judges and members of the legal community, ladies and gentlemen, good morning. Thank you very much for inviting me to address you today at this 9th Regional Arbitral Institutes Forum Conference and to play a part in the inaugural KL RCA International Arbitration Week. In his kind introduction, Sudha referred to my peripheral involvement in the formation of the RAIF, and I must say it's personally very heartening to note the advances that have been made in the last 8 years. Here in the new home of the KLRCA, the Regal Bangunan Sulaiman, we are reminded that international arbitration is intertwined with the history and culture of our civilizations. It has been rightly said that arbitration is the oldest method for the peaceful settlement of international disputes. In the commercial context, there's evidence that private parties used arbitration to resolve their disagreements well over 4,000 years ago in ancient Mesopotamia, Egypt, and Greece. However, today I'll be focusing not on our past, but on the future, as I see it, of international arbitration within the wider tapestry of transnational commercial dispute resolution. Sudha said that I may have some answers. I must quickly address that in case it takes root. I'm actually going to leave you with more questions. The prevalent modes of dispute resolution which make up this tapestry can be divided into two broad categories. Adversarial dispute resolution forums such as the courts and arbitral tribunals, and consensual forums like mediation. While lawyers are well acquainted with the combative arena of courts and arbitral tribunals, my thesis for today is that as we move into the future, commercial parties will be increasingly attracted to other dispute resolution methods that are not purely adversarial in nature. The lecture will be divided into four segments. First, I will look at the current state of the transnational commercial dispute resolution landscape. Second, I will outline some of the challenges which adversarial commercial dispute resolution forums in particular are facing. In my third and last segments, I will look at what we can expect as we head into the future and how international commercial arbitration will be transformed by the shift towards a more consensual approach towards commercial dispute resolution. My lecture will be focused on transnational commercial disputes between private commercial parties, purely domestic parties, and public international law disputes, including those between commercial parties and states under a bilateral investment treaty, though very current and interesting, will not be examined. I begin with the current state of transnational commercial dispute resolution. There are three trends which are prominent. First, over the past decade, there has been a marked decline in the number of civil and commercial disputes adjudicated by the courts in the leading common law jurisdictions. In Australia, for example, the amount of civil litigation per capita from 2001 to 2013 declined by a sharp 45%. Similarly, in Singapore, there was a 27% fall in the number of civil originating processes from 2003 to 2013. There's one notable exception to this trend, the Commercial Court of England and Wales, which has actually seen an increase in its caseload over the past decade. I will touch on these unique features of the English Commercial Court, which account for this deviation later. But if we take into consideration the other branches of the English High Court's Queen's Bench Division, we find that there was a similar 30% fall in the number of civil proceedings handled in London from 2002 to 2013. It is unlikely that the reason for this trend across the major common law countries is simply that their societies have become less litigious. As I will elaborate later, the most plausible explanation is that there has been a flight of civil and commercial cases away from the courts to other dispute resolution forums, such as arbitration. This brings me to the second significant trend over the last 10 years, the rise of arbitration as the leading forum for the resolution of transnational commercial disputes. The statistics published by the leading arbitral tribunals are remarkable. The ICC saw a 36% increase in the number of requests for arbitration from 2001 to 2014. Likewise, the Arbitration Institute of Stockholm, the SEC, saw a 20% increase in its caseload from 2003 to 2013. In the same period, the London Court of International Arbitration experienced a 201% increase in its workload. In our own region, the Singapore International Arbitration Centre noted a dramatic 305% increase in the number of cases it handled from 2003 to 2013. The KL meanwhile, witnessed a staggering six-fold increase in its workload from 2010 to 2013. So, while commercial parties appear to have retreated from the courts, they have clearly embraced international arbitration. Stepping away from adversarial proceedings, we observe the recent emergence of forums for the resolution of disputes which rely on consensus and conciliation. This is the third trend which is prominent in today's dispute resolution landscape. The emergence of non-adversarial dispute resolution is most palpable in mediation. In the UK, for example, there's been a boom in consensual dispute resolution with a 58% increase in civil and commercial mediations from 2010 to 2014. This trend, however, is particularly marked in Asian jurisdictions. In Singapore, there was a 57% increase in the number of cases mediated by the Singapore Mediation Centre in just 1 year, from 2013 to 2014. China, too, has a strong culture of mediation, reflecting the Confucian virtue of harmony, or, pardon my pronunciation, He Wei Qiu, that disputes among the people ought to be resolved whenever possible by methods of discussion, of criticism, of persuasion and education, not by coercive, oppressive methods. Mediations of civil and commercial cases in China is primarily conducted through the courts, and judges play an active role in resolving disputes consensually, with the percentage of civil cases resolved by judicial mediation per year increasing by 26% from 2008 to 2010. Islam has a rich tradition of promoting the amicable resolution of disputes as well. Evidence suggests that mediation was a common practice within the Ottoman Empire. There are also various references to conciliation and mediation found in the Quran and the Sunnah. It is thus no surprise that there is a large volume of commercial disputes which are mediated by Middle Eastern tribunals. The Dubai Center for Amicable Settlement of Disputes, for example, handled over 4,000 commercial mediations in the first 3 years following its launch in 2011. In the same vein, informal mediation by family members and village elders through the panchayat has always been a part of Indian culture. While this was supplanted by the common law adversarial system under the British Raj, there are signs that consensual dispute resolution is playing an expanding role in modern India. The 5 mediation centers annexed to the Delhi courts, for instance, have handled over 120,000 cases since the opening of the first Delhi Mediation Center in 2005. Last but not least, there's indication that mediation has long been a feature of our own region. Within the indigenous Malay community since the 1600s or even earlier. In Malay villages, the head of the community, the Penghulu or Ketua Kampung, employed a sophisticated mix of strategies, including actively gathering information, meeting each side separately, and calling for concessions in order to resolve disputes. The mediation practice direction issued by the then Chief Justice Tun Zaki Asmi in 2010, urging judges to give directions that facilitate settlement by way of mediation, proves that this tradition of providing or promoting conciliation is alive and well in Malaysia. Mediation is thus emerging as a key component of the dispute resolution landscape in Asia, but there are other consensual forums which are also gaining prominence. In the maritime industry, P&I clubs facilitate the out-and-court settlement of maritime disputes in quick and expedient manners. This has resulted in a substantial decrease in the total amount of maritime litigation and arbitration. You just look at the statistics in any of the maritime countries, London, Singapore, and even the US. Online dispute resolution is another novel aspect of consensual dispute resolution. eBay handles over 60 million disputes every year, and most of these are resolved without any human intervention. While ODR is still in its infancy, and the claims being settled online are primarily small value routine disputes, it would be naive to think that transnational commercial dispute resolution is immune from technology, which has had an impact on every other aspect of commerce. It is not yet clear what impact technology will have on our industry, but we only need to look at developments such as the emergence of virtual currencies like Bitcoin within the financial sector and the impact of Uber and Netflix on the transport and home entertainment industries respectively to realize how revolutionizing technological innovation can and will be. With that, I've set out the key trends in the dispute resolution landscape: an apparent decline in court litigation, the rise of international commercial arbitration, and the emergence of consensual forums. Will these trends continue with arbitration remaining preeminent in the field? There's reason to believe otherwise. Over the past few years, increasing discontent has been directed at the international commercial arbitration industry and adversarial commercial dispute resolution more generally. In this second part of the lecture, I shall explore some of the grievances. Before examining arbitration, it is worth asking why it is reasonable to infer that commercial parties have drifted away from the courts to other forms of dispute resolution. First, national courts are ill-equipped to deal with transnational disputes. Domestic legal systems were not designed to deal with complex cross-border disputes and generally lack the structure and expertise required to handle the difficulties which arise when a single dispute has resonance in several jurisdictions. Take the facts of the famous case of Carlyle and Carbolic Smoke Ball Company, which will be familiar to every student of the law. Imagine if the Smoke Ball Company was a multinational firm established in the Cayman Islands with offices in London, Kuala Lumpur, and Shanghai. Also imagine that it published its infamous advertisement online rather than in the Pall Mall Gazette, with its website being hosted on a server in Ireland. Finally, envision that the claim was brought not by Mrs. Louisa Elizabeth Carlyle of West Dulwich, London, but by parties from the USA, Dubai, and Singapore. Even before we arrive at the issue of whether the company has to pay the £100 reward because the claimants caught the cold while using its Carbolic Smoke Ball, we find that there are a host of problems surrounding jurisdiction, choice of law, and foreign evidence which need to be addressed. The company is also likely to face the headache of juggling multiple proceedings in different countries and the possibility of conflicting judgments. In short, the case would be nothing short of a nightmare, except for the legal professionals involved. And it needs a forum specially tailored to transnational disputes, such as the International Arbitral Tribunal. Next, court proceedings are also notorious for being onerous, slow, and expensive. The flag bearer for this line of criticism is the formal discovery process. A comprehensive 2012 study by the Rand Institute of Civil Justice has revealed that the average cost of disclosure per gigabyte of data processed is around $26,000 US. I accept the fact that discovery in the US is at another level, but even in Commonwealth jurisdictions, and this includes jurisdictions where many of you come from, discovery has taken a life of its own. It's an industry of its own. In one application for pre-action discovery before the English High Court, the claimant requested for production of about 1.9 terabytes of data, which the court heard was equivalent to 850,000 lever arch files. If we apply the earlier estimate, this data would have cost nearly $50 million to disclose, even though the claim itself was a fraction of that sum. There's technology available which can ease the pain. In a forward-looking judgment handed down in March this year, Judge Andrew Peck of the Southern District Court of New York gave approval to technology assistance review or predictive coding in the case of Rio Tinto and veil. Predictive coding involves the use of software rather than lawyers to do the heavy lifting in deciding whether documents are relevant or privileged. It goes beyond the simple keyword search technologies which are commonly used and employs sophisticated rating and self-learning algorithms. These make predictive coding at least as accurate as traditional eye-on review by lawyers, if not more so. It is also estimated that the process will result in substantial cost savings of up to 86%. However, there's no indication that the courts in other jurisdictions will be embracing this technology in the near future. So the exorbitant cost of litigation and formal discovery, the terror of the tetrabyte, if you will, continues to frighten commercial parties away from the courts. This is worrying, as only the courts can issue binding precedents to develop and advance commercial law and practice. Such precedents are important in industries where authoritative pronouncements on legal issues with market-wide significance are necessary. Think, how far back was it since the Supreme Court and its predecessor, the House of Lords, issued a leading judgment on contract law? You'll have to think very hard. The financial sector is one such industry where there is a compelling need for guidance on how terms should be construed in industry-wide documentation, such as the ISDA Master Agreement. At a higher level, the court's role in developing and harmonizing the common law is vital to global commerce as a whole. Judges ensure that the law keeps pace with the developments in the business world and in other legal jurisdictions. So the freezing of the common law caused by the marked decline in court litigation is unfortunate. Next, moving on to international commercial arbitration, there has been a torrent of criticism which has been leveled at the industry in recent years. I shall highlight just two areas of discontent. First, there's a lack of an ethical framework to guide the increasingly diverse body of practitioners, both counsel and arbitrators. Even if everyone involved in the arbitration procedure acts honorably and in good faith, this lack of common professional standards is problematic due to the disparity in ethical norms between different jurisdictions. Let me illustrate this. What should a lawyer do when a precedent damaging to his or her case is uncovered? In common law jurisdictions, where the advocate owes an independent duty to the tribunal, the unfavorable authority has to be brought to the arbitrator's attention. In Germany, Latin America, and elsewhere in the civil world, this would be inconceivable. I'm not suggesting the lawyers are unethical, it's just that they work on a different framework. There are many other areas, such as the extent to which witnesses can be prepared for testimony and the rules of discovery, on which practitioners from different backgrounds will have different responses. Hence, we are faced with an uneven ethical playing field which is ripe for abuse and has been abused. Second, commercial parties have expressed dissatisfaction with the judicialization of arbitration. The 2013 International Arbitration Survey by PwC and the Queen Mary School of International Arbitration, for instance, found that this was a recurrent theme in the interviews which were given by clients from various sectors. While arbitration first emerged as an informal and efficient means of resolving disputes, it has increasingly become more complex procedurally over time and now mimics litigation in many respects. The consequences of this has been a corresponding and substantial increase in both costs and delay. Unsurprisingly, the 2013 International Arbitration Survey indicates that the top two reasons given by respondents as to why arbitration is not suited for the industry is that it's more costly and takes longer than the available alternatives. This phenomenon has been attributed to several factors, including A, the increased complexity of the procedural rules put in place by arbitral institutions, B, the reluctance of arbitral tribunals to depart from a strict application of these rules for fear of endangering the validity and enforceability of an award. C, the greater involvement of lawyers who tend towards being predisposed to formalized proceedings. And D, the lack of an appeal process which places additional stress on both counsel and arbitrators to ensure that the right result is achieved, even if this costs disproportionate time and money. Thus, commercial arbitration is today seen by a significant body of commercial players, and all of us need to appreciate that, as a less favorable forum for resolving disputes today than it was in the past. There clearly can be no guarantee that the remarkable growth trajectory in the industry we have observed over the past decade will continue apace into the future. More fundamentally, adversarial commercial dispute resolution itself is not desirable in many cases. As Roscoe Pond famously noted, the common law doctrine of contentious procedure turns litigation into game. It is a game with only one winner and one loser, with both parties invariably antagonizing each other. While this may not be a problem when the parties are either unconnected or bitter rivals in the same industry, it is unacceptable in the majority of cases where the parties need to continue dealing with each other. In such instances, it is in their rational self-interest to reach a settlement facilitated through a consensual forum like mediation. This analysis is supported by the 2013 International Arbitration Survey, which found that the need to maintain ongoing business relations is an important consideration for parties in deciding whether to commence legal proceedings. It also explains why P&I clubs have been so successful in brokering settlements in the maritime industry. More ship owners are contracting with the same charterers, and both sides have wisely calculated that it's worth taking a less favorable settlement offer in order to maintain a long-standing relationship. Thus, consensual forums force us to re-examine the orthodoxy that transnational commercial disputes have to be resolved through adversarial proceedings. This brings me to the next segment of my lecture. So far, I've covered the broad trends in dispute resolution over the past decade and some key grievances surrounding adversarial commercial dispute resolution in particular. The question that naturally follows is where we headed next. I start with the courts. While it's tempting to think of the courts as ever-fixed marks, both unchanging and unwilling to change, the truth is more fascinating. Among the leading jurisdictions, there's an increasing realization that something has to be done to arrest the alarming decline in litigation before the courts. State-funded courts, too, have to innovate and adapt if they wish to remain relevant players in transnational commercial dispute resolution. And so, we will see the rise of international commercial courts. These are domestic courts rooted in the legal system of their home jurisdictions, but specially created and tailored in terms of structure and personnel to meet the needs of transnational commercial disputes. The Commercial Court of the High Court of Justice of England and Wales, established in 1895, is widely regarded as the forerunner for international commercial disputes. Now seated in the Rolls Building in London, the English Commercial Court has always had an international outlook and draws in litigants from all corners of the globe. It is remarkable that since 2010, around 80% of the cases heard in the court each year have involved at least one party from outside the UK, with almost half of all claims involving only foreign parties. The appeal of the English Commercial Court lies largely in the global standing of English commercial law, the fairness and consistency of British judges, and the ready access to quality representation in London. These qualities explain why its workload has kept increasing despite the overall decline in commercial litigation. Of younger vintage are the international commercial courts of Dubai, Qatar, and more recently Singapore. The last of these, the Singapore International Commercial Court, SICC for short, was launched in January this year. These courts are exciting for two reasons. First, unlike the English Commercial Court, which developed in its international status over time, these courts were deliberately created and designed with the aim of serving transnational commercial parties. Next, because of this fundamental goal and their youthful flexibility, the Qatar International Court and the Dubai International Financial Center Courts and the SICC have been unafraid to adopt bold procedural innovations. While not all of these innovations may succeed, I believe that this process of experimentation is necessary. It offers reasons for litigants to be drawn back to the courts. Many of these innovations have been inspired by accepted practices in international commercial arbitration. The SICC, for instance, allows questions of foreign law to be determined on the basis of submissions rather than pleaded and proved as fact. In cases which have no substantial connection to Singapore, the parties may also agree to have their matter conducted in camera, emulating one of the principal attractions of arbitration to many parties. Similarly, both the SICC and the DIFCC allow for simplified discovery premised on IBA rules, tackling head-on one of the major areas of discontent with the traditional court system. Whilst they've drawn from arbitration, the international commercial courts are ultimately still rooted in their national legal systems. This allows parties to benefit from powers that are generally unique to state-backed judiciary, such as the ability to join third parties. More importantly, the international commercial courts are able to hand down binding precedents in order to harmonize and advance commercial law and practice. This, as I explained earlier, is vital to global commerce as a whole and crucial for parties who need authoritative pronouncements on tricky legal issues which impact their entire industry. If the flight of cases to arbitration has resulted in a freezing of the common law, the international commercial courts may prove to be the spark that thaws the ice. Given the competition from the international commercial courts and the grouses it already faces, the arbitration industry cannot stand still. In my view, there are three broad areas within international commercial arbitration where we can and should expect vigorous development. First, we can expect greater regulation of the conduct of both counsel and arbitrators in the coming years. The crucial question is what form this regulation will take. Can we avoid regulating ourselves out of existence, as one leading practitioner put it? I believe we can if we adopt the right approach. The wrong approach would be to do nothing. Some have suggested that we wait for arbitral self-regulation to develop organically. Even if this does happen, it is likely to take time, during which we risk further damage to the industry's reputation. More fundamentally, any organic self-regulation such as the due process protocols developed by the AAA is likely to be jurisdiction or institution specific. What we need is a universally accepted transnational code of ethics for arbitration which goes beyond common sense principles which bind all lawyers, like the duty to act honestly. Such a code must deal with the contentious ethical issues on which our legal cultures differ, such as those I've touched on earlier, concerning witness preparation, document disclosure, and the question of whether an advocate owes an independent duty to the tribunal. Crucially, the code must provide useful guidance on these areas and eschew the tendency for such documents to be filled with vague and general pronouncements that no one can disagree with. While this may seem an ambitious project, there are some promising signs that such a code may soon arrive. In May 2013, the IBA published its guidelines on party representation in international arbitration to deal precisely with today's uneven ethical playing field. These guidelines are not a complete answer. They only apply to the extent parties adopt them, are too brief, and are purely concerned with the conduct of legal representatives, leaving out arbitrators. Nevertheless, they are the first step in the right direction. The IBA guidelines foreshadow the development of a more comprehensive transnational code, which I believe will gradually be adopted by the leading arbitral institutions. The widespread currency gained by the similar IBA guidelines on conflicts of interest and the IBA rules on disclosure paved the way to this development. Once adopted, this ethical code must be enforced, perhaps by the arbitral institutions themselves. This will give it the bite which the current IBA guidelines on party representation lack. While I acknowledge that it is less clear what impact such a code will have on non-institutional arbitration, one possibility is that it may be incorporated directly into the governing rules on arbitration, such as the ancestral arbitration rules. Practitioners within ad hoc arbitration will then be subject to the same transnational ethical standards. Moving on to the second area for development, I believe that the arbitration industry will have to embrace innovations that promote efficiency and speed. While we practitioners may perceive the exhaustive processes which typify arbitration today as necessary to reduce errors and ensure the right result, clients are more likely to see the enterprise as simply unwieldy, exhausting, and specifically designed to benefit the balance sheets of lawyers. In order to mitigate these concerns, any new idea that could lead to a reduction in cost and time will have to be looked at closely. Fast-tracked or expedited arbitration is an example of a recent innovation that now appears to have gained widespread acceptance. This is specifically provided for in the ICC and SIC rules, whilst the KL RCA and SEC have gone further and enacted separate rules for fast-track arbitration. The LCIA also readily allows its rules to be adapted for an expedited process. While there is the fear of an unsatisfactory result being reached due to the pressure of time and concerns over the protection of due process rights, my view is that these risks can be managed if sensible deadlines are set and the parties involved act in a proactive and professional manner. In principle, there is no reason why the award of a tribunal should be looked down upon simply because it's the outcome of an expedited process. The Singapore High Court has very recently confirmed this view in AQZ versus ARA. This was the first case in which Singapore dealt with an application to set aside an award under the SIC's expedited procedure. The dispute arose out of a contract for the supply and purchase of coal and was resolved by fast-track SIC tribunal in 10 months. From July 2013, when the arbitrator was appointed, to the date of the award in May 2014. The supplier challenged the award in the High Court, and one of its arguments was that it had not consented to the expedited process, as the arbitration agreement had been made before the SIC changed its rules in 2010 to allow for fast-track arbitration. Nevertheless, the High Court upheld the award and stated that as long as the parties agree to the SIC rules, no express assent is necessary for the expedited procedure. The case hence confirms that fast-track arbitration will be given ample support by the courts. It is an expedient and effective dispute resolution mechanism on the rise. The summary award procedure, analogous to the summary judgment procedure available in court proceedings, is another example of an innovation that has yet to gain widespread acceptance but may eventually do so. Under the SIAC rules, there's available to parties who have agreed to arbitrate under the SIAC domestic arbitration rules. Summary award procedures or procedures to similar effect can also be found in the rules of JAMS and the AAA. Although some have criticized summary award procedures as open to abuse by recalcitrant parties to delay proceedings, it's a welcome innovation which allows frivolous claim defenses to be expeditiously disposed of. Next, to make discovery cheaper and less daunting, new technologies like predictive coding have to be embraced. The report by the RAND Institute for Civil Justice, which I cited earlier, has found that the reason why such technology has not been more widely adopted include inertia and a discomfort with the idea of being an early adopter. While such conservatism may be justified if harbored by the courts, the arbitration community must be bolder. Given the transformative potential of technology-assisted review, we cannot afford to be Luddites, especially after the landmark judgment in Rio Tinto against Vail. Finally, there have been a multitude of other procedural ideas in recent times which have the potential to increase efficiency within arbitration. Some of these devices are now well established in arbitral procedure and include the well-known Redfern schedule, which simplifies and expedites the discovery process by allowing parties to easily input and access requests for documents, production, submissions on discovery, and the subsequent decision of the tribunal. The Scott schedule, the read retreat for the tribunal to discuss the case prior to the hearing, the SACS protocol, which posits a hybrid of the civilian and common law systems for the appointment of expert witnesses, and the Kaplan opening, an initial hearing prior to the main affair, which allows the tribunal to get an early flavor of the case. These procedural innovations do not fundamentally alter the nature of international commercial arbitration, but they do indicate that there's room for efficiency gains within the current framework. More importantly, these innovations offer a promise that, if taken seriously, the very real concerns about the judicialization of arbitration and the consequent delays and spiraling of costs can be surmounted through the exercise of pragmatism. Third and last, I foresee an increased specialization of institutes and tribunals within the arbitration industry. Specialization is a trend pervasive across all fields of economic activity, but international arbitration, commercial arbitration, is particularly ripe for it, given the wide spectrum of subject matters arbitrated and the complexity of the disputes. The launch of Prime Finance in The Hague, the start of 2012, is an example of this. This is an institution that caters to the needs of arbitration users involved in complex financial disputes. So its rules contain distinctive features such as the provisions for anonymized excerpts from awards to be made public, so as to facilitate the creation of a corpus of case law in the area of complex financial products. Its panel comprises an impressive list of experts with deep knowledge in both finance and dispute resolution. Although it is still early days, there's every reason to believe that Prime Finance will succeed, particularly if it manages to persuade users of the ISDA master agreement to elect for its arbitration rules. Besides finance, there are many other areas where there are already specialized arbitration bodies. These include maritime and salvage, commodities, insurance, and intellectual property. Not all of these industries, however, have institutions that cater to transnational disputes like Prime Finance. This is likely to change. As the international arbitration industry grows and transnational commercial disputes become more specialized and complex, it is inevitable that we will see the growth of specialized international arbitral institutions and tribunals. Moving away from proceedings which are purely adversarial, I believe that the most important development as we move ahead will be the proliferation of hybrid forms melding both adversarial and consensual dispute resolution. Earlier, I outlined the emergence of consensual forums and mediation in particular. I also posited that one of the fundamental problems with adversarial commercial dispute resolution is that it harms the commercial relationship between parties who regularly transact with each other. Taken together, these two observations ostensibly lead to the conclusion that mediation will gain prominence and that its growth will be at the expense of arbitration. This reasoning, however, ignores three weaknesses with mediation in practice. First, it's not always easy to bring parties to the mediation table. Unlike arbitration clauses, an agreement to mediate or negotiate is not readily enforceable in quite a number of jurisdictions. There are, however, indications that the tide is turning. In our own region, the Singapore Court of Appeal in HSBC Trust Services versus Toshin makes it clear that a clause which stipulates for disputes to be resolved through good faith negotiation will be given legal effect in Singapore. Here I must declare my self-interest as I authored this judgment. The court was of the view that such clauses are in the public interest as they promote the consensual disposition of any potential disputes. Toshin was recently referenced with approval by the English High Court in Emirates Trading versus Prime Mineral Exports, which held that an agreement to first seek to resolve any dispute by friendly discussion before commencing arbitration is binding. In reaching this decision, the court also relied on the Australian decision in United Group Rail Services and Rail Corporation, New South Wales, where the New South Wales Court of Appeal similarly held that a negotiation clause is enforceable. These decisions indicate that the common law's long-standing aversion to the enforcement of agreements to mediate or negotiate, which can be traced back to the controversial House of Lords judgment in Walford and Miles, is slowly abating. However, this is still a highly contentious area of the law, and it cannot yet be said we have reached a conclusive position on this issue. Second, even as the most ardent advocates of mediation have to accept, it does not invariably result in successful settlement. While settlement rates are impressive and as high as 86% according to a recent study, there will always be disputes which cannot be resolved consensually. Even if mediation generally results in settlement, you can never be certain that your particular case will be resolved amicably. Third, even if the first two hurdles are overcome, the foreign enforcement of settlement agreements is not always a straightforward matter. There is, as of yet, no equivalent of the New York Convention for mediation. So, if one of the parties reneges on a settlement agreement, the aggrieved party will generally have nothing but ordinary contractual principles to rely on if it wishes to enforce the agreement in a foreign jurisdiction. Due to these difficulties, parties are likely to find that mediation on its own is inadequate for the resolution of complex transnational commercial disputes. This is why the future belongs to hybrid dispute resolution mechanisms, which marry both the adversarial and consensual forums. The most well-known of this is the mediation arbitration, or MED-ARB, where the same neutral person acts first as the mediator and then as arbitrator if mediation fails. There are other variations like arbitration, mediation, arbitration, or MED-ARB. As the name suggests, the mechanism starts with arbitration before moving on to mediation. If the parties reach a settlement, this is recorded as a consent award. Otherwise, the parties return to arbitration. In Singapore, MED-ARB was given a substantial boost with the announcement of a new protocol between the SIAC and the newly formed Singapore International Mediation Center in November last year. To meet one of the main concerns surrounding MED-ARB, that the neutral party qua arbitrator will be tainted by the confidential information he receives when acting as the mediator, the two processes will be conducted by different individuals under the same SIAC-SIMC protocol, unless the parties agree otherwise. There are substantial advantages to such hybrid mechanisms. First, agreements to resolve disputes through such multi-tiered mechanisms are more likely to be enforced by the courts. Unlike bare agreements to mediate or negotiate in good faith, these agreements are specific in nature, stipulating fixed time frames for the transfer of the dispute from mediation to arbitration or vice versa. Hence, one of the principal legal objections to the enforcement of mediation and good faith negotiation clauses that they lack the necessary certainty is met. In the Emirates trading case, for example, the dispute resolution clause specified that the arbitration can be invoked if the mandatory friendly discussions do not yield a solution within 4 weeks. The English High Court held that this was a complete agreement which was sufficiently certain to be enforceable. One of the authorities cited by the English court in reaching this conclusion was a judgment of the High Court of Singapore in the International Research Corporation versus Lufthansa Systems Private Limited case. In Lufthansa, there was a multi-tiered dispute resolution clause which stated that any dispute was to be first put through a specified mediation procedure before arbitration could commence. The first instance judge held that this agreement was certain and enforceable. The case then went on to the Singapore Court of Appeal. While the appeal was allowed for other reasons, the Court of Appeal agreed with the High Court that the clause was clear and mandatory. I'm confident that similar position will be taken in other leading common law jurisdictions, as such clauses are clearly distinguishable from bare agreements to negotiate in good faith. Next, such hybrid forums are more likely to ensure that disputes are resolved expediently and amicably. For the majority of cases amenable to consensual dispute resolution, the looming threat of arbitration will focus the mind of the negotiating parties. The strict time frames will provide a discipline which is often lacking in mediation. As for cases that cannot be resolved amicably, the secondary adversarial mechanism serves as a safety net which ensures that the parties are not left stranded when mediation fails. The fact that mediation was conducted would be beneficial even in such cases, as the consensual process would probably have narrowed the field of dispute. The arbitration can then be conducted in an expeditious and purposeful manner, while the damage to the parties' commercial relationship could be kept to the minimum. Finally, the twinning of mediation and arbitration allows for any mediation settlement to be recorded as a consent award by the arbitrator. The settlement can be easily enforced in any of the 154 states which are party to the New York Convention. Hence, hybrid resolution forums are binding, effective, and dependable. They are binding as the courts are willing to enforce multi-tiered dispute resolution agreements. They are effective as they combine the flexibility of consensual dispute resolution with the certainty that adversarial proceedings bring. Ultimately, a ruling will be made even if the parties cannot agree. And finally, these forums are dependable as any final award or settlement will be readily enforceable in a foreign jurisdiction as an arbitral award. So, increasingly, transnational commercial disputes will be resolved through mixed forums to draw upon the strengths of both adversarial and consensual dispute resolution. In Asia, this is a development that is already taking place. The China International Economic and Trade Arbitration Commission, CITIC, for instance, already resolves 20 to 30% of its caseload through MEDA. Similarly, the arbitrators of the Japan Commercial Arbitration Association regularly assist parties in reaching a settlement and have a success rate of more than 50% when they take on this mediatory role. These statistics, I don't think, are just dependent upon the culture. They reflect a preference for collaboration over competition, which I think over time business people will gravitate towards. As Asia rises, this disdain for adversarial forums will have a seismic impact on the landscape of transnational commercial dispute resolution as it stands today. How should the arbitration industry respond? At least one commentator has predicted that the legal industry will resist any move away from arbitration towards consensual forums, not for any noble or principled reason, but because this will result in a significant loss in income for the legal community. This should not be the case. The health of a profession cannot depend on disputes being unnecessarily prolonged. to increase the number of billable hours. There are few surer ways to drive away clients. In any case, mediation will not supersede arbitration. Rather, the two forms of dispute resolution are likely to converge, creating new and exciting opportunities for practitioners of international commercial arbitration. Another possible reason for the scorn sometimes poured on consensual forums is the desire to argue and seek confrontation, which is part of the common lawyer's DNA. An advocate used to the sound and fury of the courts and their own voices may find the tranquil environment of mediation unsettling. However, I'm confident that as professionals, all of us can adapt. Greater focus has to be placed on the skills necessary for mediation and negotiation earlier on in a lawyer's career, and our law schools must also generate interest in these topics. Ultimately, it is in the long-term interest of the international arbitration community to embrace the shift away from an exclusively adversarial approach towards dispute resolution. To quote Alan Watts, the English philosopher who popularized Eastern philosophy in the West, the only way to make sense out of change is to plunge into it, move with it, and join the dance. Before leaving aside the business of law, I believe that supporting this move away from adversarial commercial dispute resolution is in line with the higher duty we owe as legal professionals to society. Although we spend much of our time in heated debate crossing swords with each other, we must not forget that our role is to resolve rather than to create conflict. Especially in this age of discord and strife, consensus and conciliation are fundamental values our legal system should promote. Before I end, I'd like to thank Professor Sundra Raju, his colleagues, for their hospitality and their kindness in inviting me today. I also want to acknowledge the presence of Dr. V. Salvaratnam, who persuaded me to come here. And I'm glad I did, because both Singapore and KL are not competitors. They can complement each other. And I'm glad that the legal communities in both jurisdictions are working together. With that, I wish you a successful conference. Thank you very much.